where accused is awaiting trial, we have a convicted murderer applying for bail. So the conditions should be stricter, and that's why we've only been swayed, my Lord, not to oppose and to make other submissions by the two issues, and that is the house arrest and the electronic monitoring. And we also agreed to an amount of bail of 10,000 rand, because in the affidavit you see it's discussed that the accused does not have the means to pay a higher amount of bail. But we're comfortable that the mere fact that the accused will be under house arrest and that there will be electronic monitoring, we will ensure that the accused remain and stand his trial. As a general submission, we're not convinced that the accused has made out a good case and that his application to the Constitutional Court will be successful, but we acknowledge that he has a right to bring such an application. And
let's go back to the issue of the house arrest.
Yes, my Lord.
It was submitted earlier that I think you could leave the house between 7 and midday. Why is it necessary to change that condition?
That was a condition of his community service and by correctional services on a charge of culpable homicide and having done a part of his sentence. This is now completely different. The accused is looking at a minimum sentence of 15 years, and this is as if he's not been sentenced. So
that for him now to be in the house for the whole day, that amounts to a punishment on its own.
Not necessarily, my Lord, with the utmost respect. It is agreement between the state and the accused for not opposing. We still believe that we'll have a good case to oppose, but knowing where the accused will be for the remainder of the day, knowing that we could monitor the accused, swayed us not to oppose. And, my Lord, we still believe that this accused, being convicted of murder, looking at a sentence of 15 years, may be a flight risk.
Now, the